The Fulton County DA's probe into election interference represents one of the most extraordinary prosecutions the country has ever seen attempted. An unprecedented set of facts, a plot to overturn a presidential election, and an unprecedented group of defendants, including an ex-president, a former White House chief of staff, and a coterie of prominent allies and advisors. The big question today in that sprawling RICO case against the ex-president and 18 others, what will the trial, or possibly trials, plural, what will they look like? There are 19 co-defendants, each with a different set of requests and priorities. One of the co-defendants is running for president of the United States for a third time. He faces 78 other felony counts in 3 other jurisdictions. In a filing last night, DA Fani Willis insists that all 19 co-defendants should be tried together, warning of a, quote, logistical quagmire if they are allowed to sever their cases. The filing reads in part, should this court grant the pending severance motions, a potential consequence could be a cascade of additional speedy trial demands emanating from the severed defendants. Each of those demands could spread out over the coming weeks, forcing the Fulton County court system to simultaneously accommodate 3 or more trials on the same facts before 3 or more sets of judges and juries. Realistically, holding 3 or more simultaneous high-profile trials would create a host of security issues and would create unavoidable burdens on witnesses and victims who will be forced to testify 3 or more times on the same set of facts in the same case. One of the co-defendants, who's pushing to be tried separately, that's former White House Chief of Staff Mark Meadows, was dealt a big legal blow in court just this morning. A federal judge denying a request by Mark Meadows for a stay of his ruling that Meadows should be tried in Fulton County, where the charges have been brought, and not, as Meadows would like, in federal court. You'll recall that Meadows has been arguing that he should be shielded from state charges and state prosecution because he was acting in his capacity as a federal officer, as Donald Trump's White House chief of staff. The judge issuing once again a stern rebuke of that, saying this: the court has already determined that Meadows failed to show he is entitled to federal removal because he was not acting in the scope of his federal office at the time of the acts alleged. Courts grappling with the complexity of DA Fani Willis's case in Georgia against Donald Trump and his fellow coup plotters is where we begin today with some of our most favorite reporters and friends. National investigative reporter for the Washington Post, Carol Leonnig, is here, plus former lead investigator for the January 6th Select Committee, Tim Heaphy, is back, and former top official at the Department of Justice, Andrew Weissmann, is back with us as well. Carol Leonnig, I start with you and Meadows and his highly regarded attorney, George Terwilliger's recent string of legal setbacks. I think Meadows had been blessed both by better than average representation in George Terwilliger, and certainly better than it seemed Trump and some of the other coup plotters had. But he has now had a steady string. I think this is the 3rd day we come on the air with a new legal development that represents a judge ruling against Mark Meadows.
Right, Nicole. And I mean, I think it's important to note that he has serious counsel, someone who's not playing at being an attorney, but has been one for a long time and has been within the body of the Department of Justice in senior roles. I think that the losses for Meadows are not entirely unanticipated, not shocking. I don't think I would have been shocked if there were small ways in which a judge ruled in his favor either. I feel pretty strongly, having covered a lot of these kinds of cases, that Meadows had maybe the best argument among all of the other 19 for claiming that he had some sort of federal official role. But there were huge problems in that argument factually, and you and I have talked about them already. Some of the overt acts that Fani Willis spells out in her indictment may not be the strongest in terms of accusing Meadows of a crime, but they certainly raise questions about whether or not he was acting as a normal White House chief of staff staff in specific moments. I'm thinking in particular of him deciding on his own whim, as he says, to go and visit an audit of elections in Georgia. There doesn't seem to me to be anything criminal about that on its face or on its as a standalone, but it certainly raises questions about why a White House chief of staff wants to sit in on such an event that was, not supposed to be public.
There is the complicated piece, too, of what Meadows was doing. And a lot of this we learned from the testimony of Cassidy Hutchinson. But Meadows was, a racehorse in the gate dying to get to the Willard, where nothing good and nothing official and nothing federal was taking place before, during, or after. Meadows got on a plane. It's not clear to me who paid. I'm sure it wasn't Meadows. But Meadows got on a plane and went to Georgia, as you just said, to oversee an audit. There's no federal role in that. There's no official role in that. No federal government or White House officials should be anywhere near anything like that. And because this White House made such a mockery of the Hatch Act, these aren't the sorts of things that anyone's hair's on fire over, but added up, they did build to this defeat in court where Fani Willis's team literally had the goods. They had the emails where he's communicating quite brazenly with the campaign.
I think it's pretty important to distinguish between the moments in which Mark Meadows appears to be acting as a campaign official. There is nothing, again, let's emphasize, there's nothing criminal on its face with a White House chief of staff wanting his president to be reelected and wanting to raise questions about whether or not all of the steps that legally can be taken have been taken to assess the validity of the election in specific states or even in precincts, right? But making the claim that all of these things were in your federal official role under the color of your federal job is a challenge for Meadows. And I think now, again, I play a lawyer on TV, and I don't like to be speculative. I can hardly wait to hear what Tim and Andrew have to say. But it strikes me that it is going to be nearly impossible for anyone else to make this claim based on the reception that Meadows has had in court so far.
Tim, let me play for you some of the evidence developed by you and the January 6th Select Committee, and then we'll dive in.
Who do you remember being involved in those early discussions around the Thanksgiving time regarding having alternate electors meet?
Mr. Giuliani, several of Mr. Giuliani's associates, Mr. Meadows, members of Congress.
And so to be clear, did you hear the White House counsel's office say that this plan to have alternate electors meet and cast votes for Donald Trump in states that he had lost was not legally sound?
Yes, sir.
And who was present for that meeting that you remember?
It was in our office. It was Mr. Meadows, Mr. Giuliani, and a few of Mr. Giuliani's associates.
On January 2nd, the president had a lengthy telephone conversation with Secretary Raffensperger. The White House, including the former president's chief of staff, Mark Meadows, repeatedly called or texted the secretary's office some 18 times in order to set up this call. Chief of Staff Mark Meadows took the extraordinary step of showing up at a signature audit site in Georgia, where he met with Secretary Raffensperger's chief investigator, Francis Watson, who was supervising that audit process. The day after Meadows' Georgia visit, he set up a call between President Trump and Francis Watson. The Select Committee has received text messages indicating that Mark Meadows wanted to send some of the investigators in her office, in the words of one White House aide, a of POTUS stuff, including coins, actual autographed MAGA hats, etc. White House staff intervened to make sure that didn't happen.
So I don't know if attempted bribery, a shitload of POTUS stuff is what's bleeped out there, is one of the crimes, I guess that he wasn't charged with. But I want to deal with this intent and this knowledge of illegality first. So Cipollone and Jacobs, based on their testimony to the committee, are the ones saying in all of these meetings to anyone that's listening that the plot is illegal. The fake electors plots are illegal. Meadows isn't just in the meeting, according to Cassidy Hutchinson. He's convening it. It's in his office. He's convening Rudy and all of the people orchestrating the fake electors plots. I mean, I think that before I went back and watched some of the Meadows specific evidence developed by the committee, because all of our talks about Meadows sort of swirl around the opaque nature of his status in the federal probes, I forgot how exposed he is. But he is, you know, naked with his rear end hanging out on the fake electors plot. He's essentially its quarterback.
Yeah, and he didn't deny any of that, Nicole, when he testified, right? So importantly, he had essentially agreed with the factual allegations that are in the indictment, that he was actively participating in these meetings, that he was there with the president side by side through these really sort of seminal events. He claimed to be keeping an eye on the president somehow, or it's part of his official role to ensure that, you know, that the president is staffed at these things. But his conduct during the meetings in text messages on that phone call with Raffensperger suggests far from passive observation, but active participation. He chimes in the January 2nd call with Secretary Raffensperger to actually make a false factual assertion. We know that there were more dead people than that who voted. So he's not a passive observer, as he claimed in his testimony, but rather an active participant turning the wheels of the conspiracy, facilitating this fake elector plan. So again, all of this is going to play out in court, Nicole. It looks like in state, not federal court. He'll have an opportunity to respond, but there's certainly evidence that suggests he agreed with the plan. Conspiracy, remember, is the essence of that is agreement. Is there evidence that two people agreed to commit some sort of offense? There's ample evidence of Meadows' intent that this succeed.